All right. Thank you so much for joining us today. This is our Defend Our Health November Authors Talk. We are very, very happy to have you all here today with us. Know that as we are approaching the holiday season, everyone's getting quite busy, so we really appreciate that you've decided to join us today. Today, we have a really exciting talk coming from Royal C. Gardner, who is an attorney who has worked on the Clean Water Act, both in the Department of the Army and in academia. He's going to be talking about his new book, Waters of the United States. We also have our community organizer and policy lead at Defend Our Health, Sergio Kaweke, who will be talking to us about some of the impacts of clean water policy in community, local, and state level, and what we can do as community members to make sure that our friends, our families, our communities are having safe and clean water, which is a bare minimum of what we hope that everyone has access to. So just as a quick note, Defend Our Health, we are Maine's toxics-focused nonprofit. We have for more than 20 years been working to protect families and communities from toxic chemicals through advocacy, organizing, science-based education, and policy work in Maine and nationally with partners across the country. We have successfully pushed for really aggressive, successful reductions of PFAS exposures. We've worked on plastics-related chemicals like phthalates and BPAs, and we are looking forward to talking about some of the drinking water contaminants and concerns at both the federal level and as they impact Maine and other states. So without further ado, I really appreciate both of our speakers here today, and I'm going to hand you over to Royal first. Thank you so much.
Thanks so much, Emily. Thanks for the introduction and the opportunity to be here to talk about my book, and also I want to thank you for all the excellent work that you and your colleagues at Defend Our Health do. As my book explains, these are critical times to be engaged at the local and state level, especially with respect to science-based policy. Now, most people are familiar with the acronym POTUS, President of the United States, and many people know that SCOTUS refers to Supreme Court of the United States. Far fewer people have heard of WOTUS, Waters of the United States. And what is WOTUS? Well, it's Waters of the United States is actually a statutory term, a very important statutory term that's at the heart of the Clean Water Act that was enacted in 1972. If a water is considered to be a WOTUS, then it falls under the protections of the Clean Water Act. If it is not a WOTUS, then it is the state and local government's responsibility to protect that water body if they so choose. In the summer of 2022, on the cusp of the 50th anniversary of the Clean Water Act, I thought it might be interesting to take a deep dive into the history of WOTUS. I mean, who wouldn't want to read a book about a statutory term? But it's actually much more than that. It's about the tension between respecting private property rights and protecting the environment. It's about the boundaries between federal and state governments, and it's also an illustration of the relationship between the executive branch, the judicial branch, and Congress. Let me first establish my environmental credentials. This is a photo of me in second grade for winning a environmental photo essay contest, Man's Abuse of the Environment. And so I hope this demonstrates that my environmental commitment actually predates the Clean Water Act. I was introduced to WOTUS in an odd place, in the Pentagon. I went to college on an Army ROTC scholarship, and the Army was kind enough to grant me an educational delay to go to law school before I served my time on active duty. And I got picked up for a position in the Army General Counsel's office. So this is a group of lawyers that advises the Secretary of the Army and the Assistant Secretaries on a variety of legal and policy issues. And my principal client was the Assistant Secretary of the Army for Civil Works, who oversees or attempts to oversee the U.S. Army Corps of Engineers. And as you may know, the Corps has been involved with our nation's waterways since its founding. The focus has largely been on traditional navigable waters, originally keeping them open for purposes of commerce and also for military purposes. But the Corps of Engineers has also had a regulatory program, a permit program, since the 1890s. The first part of the book goes into this history of the federal government's involvement over our nation's waters. And at that time, in the early days, the focus was really on these traditional navigable waters, such as rivers that were used for commerce. States had the responsibility for water quality. But the states, as we found, did not do a particularly good job with respect to protecting water quality within their boundaries. And this image from the Cuyahoga River, which not infrequently caught fire, or refuse on the river caught fire, illustrated that the states were not up to the task. And so in 1972, Congress did something that was revolutionary, and it totally restructured the way that the federal government dealt with water quality issues. And the enactment of the Clean Water Act was remarkable in a number of different respects. First of all, it was enacted in October of 1972 over President Nixon's veto. Nixon vetoed the Clean Water Act, but Congress, 1 month before Nixon won in a landslide, taking 49 states, Congress said, no, we think this is so important that we're going to override your veto. It was also remarkable because it was just 1 month before Congress itself was up for re-election. So here you have Congress actually legislating major legislation just a month before national elections. It was a different time, shall we say, where Congress actually took its institutional responsibilities seriously and was not a supine body with the backbone of mashed potatoes. But for our purposes today, what's important to take away is that Congress in 1972 completely rewrote water pollution control efforts in the United States. And it set a federal floor of protection, with states having the ability to regulate more strictly if they wanted to. One of the fundamental aspects of the Clean Water Act is that it prohibits, without a permit, it requires a permit for the discharge of any pollutant from a point source to navigable waters. Congress defined navigable waters to mean waters of the United States. What does waters of the United States mean? Well, the agencies that were tasked with the permit programs under the Clean Water Act, the U.S. EPA, then the Section 402 or NIPD's program, and the Corps of Engineers with the Section 404 program, went through a series of rulemakings in the 1980s and ultimately landed on a definition that covered all of these waters, covered traditional navigable waters such as rivers, as well as wetlands that were adjacent to these traditional navigable waters. The definition The regulatory definition of WOTUS also covered non-navigable tributaries and wetlands adjacent to those non-navigable waters. And then the WOTUS definition also covered other waters, so-called isolated waters, though scientists don't consider them to be isolated. But these other waters, if they had some connection to commerce. Like any revolution, there was a backlash, a counter-revolution. Some of that took place in Congress, but some of it also took place in the courts, in the Supreme Court. And over a period of about 20 years, the Supreme Court considered 3 cases applying this regulatory definition of waters of the United States. In the first one, in 1985, in a case called Riverside Bayview Homes, the court was unanimous. 9-0, the court concluded it was reasonable for the agencies to say that WOTUS included wetlands adjacent to a traditional navigable water. And here the court deferred to the agency's technical and scientific judgment. It was a simpler time. In 2001, the court went in the other direction, 5-4, and held that it was unreasonable in some circumstances for the federal government to assert jurisdiction over so-called isolated wetlands. What the court was concerned about here was the principle of federalism, was that states traditionally regulate land use. And so the court felt that if the agencies were going to move into this area that was traditionally the prerogative, the responsibility of the states, that Congress needed to speak more clearly. And then we came to Rapanos in 2006, and here the court splintered. There was no majority opinion. Justice Scalia led 4 justices that took a very restrictive view of what waters should be protected under the Clean Water Act. Justice Stevens had a more expansive view that any hydrologic connection would suffice, but he only garnered 3 of his other colleagues. In the middle was Justice Kennedy, and Justice Kennedy took a middle approach where he suggested that the Clean Water Act could cover these other non-navigable waters so long as they had a significant nexus, a significant connection, contributing in some way to the integrity of these traditional navigable waters. So, as a result of these opinions, this led different administrations to conduct a series of rulemakings where the pendulum, in terms of how much was covered, swung back and forth. So the Obama administration initiated and completed a rulemaking, and that was subject to litigation. The Trump administration came in and adopted a more restrictive view. That, of course, was subject to litigation as well. And then the Biden administration came in and moved closer to what the Obama administration. So there was a back and forth. And at that time, during the Biden administration, there was a case percolating up from the Ninth Circuit. And so the Supreme Court considered what constituted a water of the United States yet again in Sackett versus Environmental Protection Agency. In this case, which took place in the Panhandle of Idaho, the Sacketts owned a parcel of land about 300 feet away from Priest Lake. And this parcel contained wetlands that were connected to Priest Lake by a shallow subsurface flow. Almost everybody, except perhaps Justice Thomas, agrees that Priest Lake qualifies as a traditional navigable water and thus is a WOTUS. But the question before the court was whether the wetland that was 300 feet away also fell under the Clean Water Act's protection. The the Sacketts had begun to fill the property without a permit. The EPA brought an enforcement action, and the Sacketts contested jurisdiction, and the case eventually made its way up to the U.S. Supreme Court. The opening argument, the opening position of the Sacketts in their brief was that a wetland is not a water. So in terms of talking about what constitutes a water of the United States, the primary position was, hey, it's wetlands, not even a water. So this is a photograph of me and my students in one of my favorite places in the world, and certainly where I love to take my students, in Big Cypress National Preserve in the Western Everglades. And so we're in a cypress dome here, a wetland, which apparently is not a water. There were a number of amicus briefs or friend of the court briefs that were filed by interested stakeholders on both sides. There were everybody from the regulated community was filing on behalf of the Sacketts. There was a smaller group filing on behalf of the Environmental Protection Agency. I just wanted to note two. One was a brief on behalf of 12 scientific societies. I was a lead attorney for that. There was also a brief filed on behalf of a number of states, led by New York, but it also included the state of Maine in support of the Environmental Protection Agency and a broader definition of waters of the United States. The oral arguments were interesting for a number of reasons. I had the opportunity to attend the oral arguments along with my sister, who is an attorney who was on the brief. And this was actually the first time that the Supreme Court had reopened to the public post-COVID. It was also Ketanji Brown Jackson's first day as a Supreme Court justice. So you had to get in line early that day to make it in, and unfortunately we did. And when we went in, we were not particularly optimistic, but there was some reason for hope after during the oral arguments. Justice Kavanaugh, in particular, was very knowledgeable about the regulatory history of the definition of WOTUS. But alas, the court adopted Justice Scalia's rather restrictive view of waters of the United States. And in particular, the court started out by saying waters are only those relatively permanent standing or continuously flowing bodies of water, such as streams, oceans, rivers, and lakes. You might notice wetlands are not included there. With respect to wetlands, the Supreme Court said that the Clean Water Act only protects them if they have a continuous surface connection to a body of water that is a WOTUS in its own right, such that it's indistinguishable, that the wetland and the WOTUS are indistinguishable. What does that mean? Well, that eliminates just the continuous surface connection requirement, eliminates non-floodplain wetlands, such as prairie potholes, precosins, vernal pools, Carolina and Delmarva bays. Ephemeral streams are out because they're not relatively permanent. So if ephemeral streams are out, any wetlands associated with them are out. And wetlands that only have a groundwater or a subsurface connection to a larger water body are also no longer protected by the Clean Water Act. But what about this term indistinguishable? What does that mean? The court actually used the word indistinguishable or distinguishable 7 times. So it's not mere rhetorical flourish. They wanted it to mean something, I believe. And so they said that it has to these wetlands and the WOTUS need to be practically indistinguishable, making it difficult to tell where the water ends and the wetland begins. So what's the impact of that? We actually tried to explain that in our brief. I believe we were the only ones that went into this in any depth, talking about this difficult to determine or difficult to tell test. And we pointed it out. It's actually not very difficult to determine where a wetland ends and a stream begins, for example. And wetland delineators do it all the time. And if you can delineate it, you can distinguish it. If you can distinguish it, well, then it's not a WOTUS. And so, as a practical matter, this difficult to determine requirement, this indistinguishable requirement, it's an extinction event, a near extinction event for freshwater protections at the federal level. Is this Cypress Dome, where I love to take my students, a WOTUS? I think not. I think not. Not anymore. Partly, it dries out during part of the year, so there's no continuous surface connection to a larger water body. It's also separated by a road from other water bodies. So I think it's unlikely that this qualifies as a water of the United States. Let's take a look at this in terms of on a larger scale, the Greater Everglades watershed. This is some work that colleagues of mine at Stetson University did. And this is in the shaded area. This indicates pre-Sackett, before the Supreme Court's decision, areas that were like wetlands that were likely jurisdictional, that is, protected under the Clean Water Act. Are you ready to see what it is post-Sackett? Right? That's taking into account this indistinguishable requirement. It doesn't look any better in color. In the book, it's black and white, but here it is in color. And these findings are consistent with what other groups are also finding, such as the Environmental Defense Fund, when they are running analyses considering incorporating this indistinguishable test from Sackett. So what does this mean? What are the downstream effects of Sackett? It means that there's no need for a Clean Water Act permit to fill the vast majority of wetlands, freshwater wetlands, certainly in the country. And it also affects many streams. So ephemeral streams are out. That really affects protections in the arid West, for example. And it's important to note that WOTUS doesn't apply just to Section 404, to dredge and fill activities. This applies to any pollutants, including those that would be governed by Section 402 or NPDES permits. So consequently, because WOTUS is the jurisdictional hook of the Clean Water Act, federal water quality standards do not apply to a water body that is considered to be non-WOTUS. Similarly, Section 401 water quality certifications are not relevant, are not applicable to non-WOTUS. It also affects other federal environmental laws. So if there's no other federal connection and you no longer need a Clean Water Act permit, then NEPA doesn't apply, for example. So the bottom line here is that responsibility for protecting these water bodies has shifted to the state and local governments. I would like to just sort of, my publisher says, yeah, you just can't end on a down note. You have to give some hope. You have to give some recommendations. And so my last chapter does that. It's entitled Navigating the Legal Shoals. And in every every chapter I open up with a quote. So I just want to read the quote and then just a portion from the chapter. I open up with a quote from Carrie Chapman Catt in 1920. She said, "The vote is a power, a weapon of offense and defense, a prayer. Ultimately, it comes down to whom we elect for federal, state, and local offices." Suffragette Carrie Chapman Catt, founder of the League of Women Voters, recognized the importance of voting. Her statement made on the occasion of the ratification of the 19th Amendment is no less true today. The most effective way to ensure clean water for our current and future generations is to elect leaders who share that value. And in the book, I give a number of examples of how we might play offense and defense. So if you're interested in learning more about the history of WOTUS, hey, this week it's actually half price from Island Press. So get your holiday shopping done early. And I appreciate the opportunity to be with you. And with that, I will turn it over to Sergio and look forward to the discussion. Thanks.
Thank you, Roy. I really appreciate your briefing of the book and WOTUS and the Clean Water Act. My name is Sergio Kaweke. I'm an organizer with Defend Our Health. I've been with Defend Our Health for 8 years. And as an organizer, I think of my job as two things. One is I work to make sure that people are educated and have knowledge and resources on the work that we're doing, that being regulating safe drinking water or regulating chemicals out of products. So making sure that people have the resources to get the water tested and remediated, or know what products are safe to consume. And then the longer term work that I do is including people who are impacted by the issues we're working on the legislative process. So making sure that people who are impacted have a say in the decision-making process for, the solution that we're advocating for. Again, thinking about safe drinking water or products, or, any kind of chemical or toxic contaminant regulation that we're working on. I want to leave a lot of time for questions, so I'm going to try to be brief, but I mainly want to drive 2 points today. One is I want to give examples on why it is important to keep people involved in the legislative process at the state level. So I'm going to speak of some experiences that I've been part of working on safe drinking water regulation. And two, I want to talk a little bit about the importance of states taking action when there's lack of federal action, and I'm going to give examples of safe drinking water. So I'm going to talk about water, but I'm going to move away from the Clean Water Act, and I'm going to introduce the Safe Drinking Water Act, which is a piece of law enacted by Congress in 1974. So that's 2 years after the Clean Water Act. That was in 1972, as I learned today from Roy. But the Safe Drinking Water Act gives the EPA the authority to regulate contaminants in drinking water systems. So both man-made and naturally occurring contaminants that might pose a health hazard to people. This is a really important piece of legislation because there's more than 148,000 public water systems across the country, and states have to comply to these standards at a bare minimum. States also have the authority to set their own standards if they're stricter than the EPA standard, and I'm going to give examples of that later. The Safe Drinking Water Act is really important, but there's one massive loophole that we're concerned about, and that's that all residential well water are left unregulated. So they're not part of the Safe Drinking Water Act. The Safe Drinking Water Act only applies to public water systems. So this leaves around 15% of the US population without any regulations. And people are left alone in the dark, not knowing that they should be testing, or how they should be testing, or what they should be testing for. So that's 15% of people across the country. This number is a lot higher in Maine, because Maine is the state that has the highest reliance on well water use, and is 52% of the population in the state of Maine rely on well water. So that's more than half of the population that don't have to comply to any standards, or that don't have to do any testing or any remediation. And that's a big issue because we are aware of two main contaminants that we have been actively working on for the last few years, that I have been actively working on for the last few years. And those are arsenic, which is naturally occurring, and we know that 1 in 6 wells in Maine have too much arsenic, and PFAS, which we've learned more and more in the last 6-7 years. And again, people don't have to comply to any testing or remediation. When it comes to arsenic, in 2017, in Maine, we passed two pieces of legislation to make sure that there's resources for low-income Mainers to get their water tested. So people that don't have the means to pay for a test kit can apply to this waiver at the state level. And we think it's really important because, low-income people are worrying about putting food on the table. And sometimes, paying for a test kit can be cost prohibitive, especially when they're like above $100, 100, 120, 140 at least. So we passed this legislation in 2017. The second piece of legislation in 2017 was a fund to help low-income people get the water remediated if there's any contaminants in the drinking water. Both were successful. We had to overturn a governor veto at the time, so we had to get 2/3 of the Maine legislature voting to overturn the veto. But we were successful because we were working in coalition with different organizations. But most importantly, we were working with impacted people who were dealing with arsenic contamination and were invested in getting free well water testing and free remediation. So that was really important. In 2021, we were looking to refund the well water testing waiver. And we were looking to lower the standard for arsenic in drinking water as well, because federally it's 10 parts per billion. But as I said before, states have the authority to establish their own standards if they're lower than the federal standard. So we're looking for a 5 parts per billion standard like New Hampshire has been doing for the last few years. So we're advancing this policy at the state level. And one of the stories that I have is that I was working with a person who had been dealing with arsenic in her drinking water for years and had been dealing with health issues that stem from that. And when she came to the committee hearing to provide public testimony, she was sharing about the importance of arsenic well water testing and remediation and how her own experience kind of help her learn about this issue. And within her testimony, she said that she'd been drinking the water that was contaminated with arsenic from renting this house, that the owners of the house didn't tell her that, was contaminated with arsenic and that they didn't drink the water. They lived next door and they didn't drink the water from the well. So just from sharing that piece of information, the committee was appalled and alarmed that this wasn't like a requirement. So they decided to put into the bill an amendment that required landlords to do testing and disclose any arsenic contamination in drinking water. Sadly, in 2021, that bill didn't make it, but a year later, we passed a standalone bill that required landlords to disclose information of arsenic contamination in Maine. So this is just an example of why it is important to include people who are impacted by the issues we're working on, because they're the ones dealing with the problem. They're the ones who know what solutions we need to set in place. And so sometimes it is easy to forget like all the aspects of an issue. Like it's really easy to focus on one single aspect of the issue. But if we work with people who are impacted, it is kind of easy to open it up and think about what else, what we're forgetting and what else we need to be thinking about when passing policy or pushing legislation. The other example that I have is related to PFAS, which I think most of people on this webinar have some knowledge about PFAS, but we've been dealing with PFAS contamination in Maine for the last 6-7 years actively. And we're passing different pieces of legislation to deal with all the aspects of PFAS. And one of the pieces of legislation was setting a standard for PFAS in drinking water in Maine, because there was none existing at the federal level. The EPA had established an advisory level of 70 parts per trillion for 2 PFAS. And in Maine, we were looking to establish a 20 parts per trillion standard for 6 different types of PFAS. So, a lot stricter, a lot more health protective. So in 2022, we passed this piece of legislation, and 20 parts per trillion. There were other states also pushing different types of standards for PFAS in drinking water. And that generated momentum, and the EPA took notice, and they decided to launch their own process to establish a health protective PFAS level. And last year in the fall, they were keeping us updated, giving us a timeline, saying, it's going to take 1 more year. This is what it looks like. We're going to establish a 4 part per trillion standard for 6 different types of PFAS, at least. And, we were it was a slow process. We were thinking that it was going to take a while. So in Maine, this past session, we decided to put forward a piece of legislation that established the same standard at the state level in Maine. And we were successful. That bill passed, the committee passed the votes at the Senate and the House, and we established an the EPA standard at the state level in Maine. As you might imagine, with the new administration, we heard April this year that the EPA was rolling back those standards and that was not going to take place anymore. So we were like happy that, we were kind of, taking 2 steps ahead of that, and we at least established a PFAS standard in Maine. I'm not sure what other states are doing, but I'm hoping that other states are also establishing their PFAS standards after like all the work and research that we've done in Maine, especially. But I just think it is really important to make sure that states kind of are taking their own action, especially when the federal government is inactive and is not doing as much work as we hope they were doing. But I just want to highlight the importance of working at the state level to make sure that we're setting the standards, we're protecting people in the face of inaction at the federal level. And to me, as an this is my organizer hat, but as an organizer, it is really important to work with impacted people, because it is important to kind of provide the numbers and the data and use the reports and just tell people, 1 in 6 wells has too much arsenic, 10 parts per billion is too much arsenic. All that is really important. The evidence, we're evidence-based organization, but I think it is also really important to put a face to the problem and work with impacted people who are dealing with these issues, so they can come and tell legislators and decision makers, this is really important. We need this in place in Maine. I've been dealing with this issue, and this is the solution that we want to see forward. So it is helpful to put a face to the problem, because sometimes the numbers and the data and the science doesn't connect with people. So as an organizer, that's the work that I've been doing for the last 8 years, and I'm really proud of the work that Defend has been doing. And I just want to say again, working on the state level in the face of federal inaction is really important, especially these days. And I'm gonna pause there because I really want to leave time for questions, but happy to answer any questions that people may have.
Thank you so much, Sergio and Royal. That was really exciting. We do have a couple of questions that have come in, and I know we are scheduled to end at around 10:45. So I think we're going to take maybe 2 or 3 of the questions that have come in, and then we are happy to continue chatting with folks around safe drinking water. Sergio, especially if you've got any questions, he knows how to kind of navigate some of these testing programs that exist and where there are gaps to help people figure out how to still get access to testing, even if there are not always perfect systems in place. Okay, so one of the questions that came in, this is a question for you, Royal. Can states regulate waters not included in the Clean Water Act or that are not considered WOTUS? And if so, have they been successful?
Absolutely. The answer is absolutely yes. States can regulate waters. States can regulate waters that are considered WOTUS. They can protect them at a greater level than the feds if they wish to, but also for waters that are not considered to be WOTUS, the states have the authority to regulate that. The Sackett decision does not affect the state's responsibilities in that regard in any way. And in terms of states that have done so, there are a number of states that have pre-existing strong regulatory programs. Maryland, California, Minnesota. There have also been some states that have taken action after Sackett or in anticipation of Sackett, such as New York is phasing in some stronger rules. Colorado has adopted a new permit program.
This is kind of an open question for both of you. What states have protected wetlands effectively? And Sergio, for you on this, do we know of anything in Maine where wetlands have been protected and that has had an impact on PFAS or some of these other drinking and surface water contaminants?
I'm not ready to answer if you know any other states.
So in terms of states with let's say with wetland independent wetland protection programs, you could take a look at California. You could even look at Florida. So there are about half the states have some protections. The Environmental Law Institute actually has published a number of papers on this, and so that they are a very good resource. And actually, there was a recent article in the Tulane Environmental Law Journal that was written by Therese Wilkerson of the Environmental Law Institute that walks through the states that have started to increase their protections, but also some states that are starting to roll back their protections to move to the new federal floor.
Yeah, in specifically in Maine, I'm not sure of any legislation. I think there's some wetland legislation coming up this session. So if people are interested in that and connecting with me to talk about wetland legislation in Maine, I think there's at least one bill being proposed for the upcoming session.
All right, and for our last question that we have time for, this kind of follows on. Do the Clean Water Act or the Safe Water Drinking Act have any kind of role in like PFAS or microplastics at the federal level? And are there state actions happening along those lines? I'm thinking specifically, we had some of the shellfishing and fishing areas downstream from the AFFF Brunswick PFAS spill get closed because of water contamination and high levels of PFAS. So I guess, are there federal or state actions around PFAS, microplastics, some of these other emerging contaminants that people are concerned about?
Yeah, I'll defer to Sergio on this, and then I do want to make a closing point. Thanks.
Well, in the Safe Drinking Water Act, as I said, they were going to establish the maximum contaminant levels, and they rolled them back earlier this year. So there's some states like Maine who are taking action. But I'm not sure about the Clean Water Act. I have to double check what's the status on PFAS contamination and state action on the Clean Water Act front.
Yeah, I think as a practical matter, we're not going to see any action at the federal level in the next few years, and that's why it's so important about what you do at the state level, and it makes a difference, not only in Maine but in other states that may not be as blue, say as Florida, for example. There was a proposal in Manatee County to relax wetland protections for mangroves. 200 people came out to the county commission meeting and said, no, don't do it. And they went ahead and did it anyway. Next election, all 5 of those commissioners were voted out, in part because of that issue. So I mean, ultimately, I think it really does come down to voting and working with your state and local leaders.
Well, thank you both so much. As the executive director for Defend Our Health, I think this is a really important topic. And Royal, what you just said about the critical nature of communities and states not just holding the line on safe drinking water and some of these other protections around environmental and public health, but really the states being able, even in this really challenging time, to be pushing forward on health protective policies and health protective actions. We come together as community members, and we come together as voices and advocates, speaking not just about what we are experiencing, but how it's impacting our lives, our families, our friends. And we really are more powerful than we realize. So I really appreciate both of you as speakers. Thank you all for coming to our talk and listening in on this very important topic. Please take a look at Royal's book. And if you are not already on our newsletter, our listserv, working with Defend Our Health, please make sure you sign up. And we will send a recording for this event in a couple of days. So thank you so much. Have a lovely day. And we really appreciate your interest in advancing health.